हेलो।
afternoon, sir. Good
गुड
afternoon,
आफ्टरनून
ma'am.
मुस्कान।
Good afternoon,
गुड
sir.
आफ्टरनून।
किस शहर से हैं आप राजस्थान में?
Sir, I am from Punjab, basically, from Nagpur.
अच्छा,
Yes, sir.
पंजाब जुडिशियल सर्विस में नहीं आपने ऑप्ट किया कभी?
Sir, actually, I graduated in 2025 itself. So the Rajasthan was the first state I was eligible for.
ओह,
Yes, sir.
कहाँ से आपने एलएलबी किया है?
Sir, Rajiv Gandhi National University, Patiala.
वेरी गुड, वेरी गुड। इसमें तो सिलेक्शन बाय इटसेल्फ इज अ टफ जॉब। क्या एक्सपीरियंस रहा आपका लॉ करके, लॉ पढ़ के? आपको क्या लगा कि कौन से सब्जेक्ट बहुत ज्यादा इंटरेस्टिंग है, कौन से कम इंटरेस्टिंग है?
Sir, I found criminal law very interesting. I am currently pursuing LLM in criminal law only. Uh, as far as boring, I don't feel any subject is boring, but it may be that tax laws and corporate laws don't seem so much interesting to me.
अच्छा, वेरी गुड। तो क्रिमिनल लॉ पढ़ने के लिए तो फिर जैसे कुछ एक कनेक्टेड सब्जेक्ट्स तो है ही, एविडेंस एक्ट है, जूरिस्प्रूडेंस है, ये
Yes,
सब में भी पढ़ा ही होगा आपने,
yes, sir.
है ना?
Yes, sir.
तो आपको क्या लगता है कि जो पुराने एक्ट्स रिपील करके नए एक्ट्स लाए गए हैं, इज दिस बीन अ वाइज मेजर, और ये छोटे मोटे अमेंडमेंट्स करके भी वो पर्पस अचीव हो सकता था जो इन नए एक्ट्स को लाके हुआ है?
So I feel that amendments were needed because of the colonial mindset and because of many provisions were redundant. Though amendments were needed, as far as introducing a new legislation, it is very difficult to remember all the new sections and all the new jurisprudence that will be associated with it. So I feel that amendments could have also served the purpose. Also, CRPC was introduced in 1973 itself, so it is after independence. So it could have remained same after amendment. So I feel amendment could have been better.
प्रोसीजरल लॉ की वजह से ट्रायल्स में डिले होता है, ये बात कहाँ तक सही है?
So procedural laws, when they become too rigid or when the parties take advantage of it, then it leads to delay. But if they are followed properly, for example, timelines are followed properly, then it will lead to better justice in a timely manner.
तो इसके लिए ये फॉल्ट किसके ऊपर जाता है? व्हाई आर दोस लॉज नॉट फॉलोड, द प्रोसीजरल लॉज?
So one reason could be the parties. For example, a lot of time in taken in summons. Parties are avoiding summons, and in execution also we see that in execution, in executing the order, a lot of time goes. So sometimes it is a party responsible. Sometimes it is due to the procedures involved. That like they have to file reply, and then first an application is filed, then a reply is filed, then a rejoinder is filed. So it lot of applications also lead to delay. Rather, there should be they should confine to the pleadings that they have submitted. So this also leads to delay.
दो तरह की एप्लीकेशंस होती हैं। एक तो होता है कि जिसमें कोई, अगर आपने उस एप्लीकेशन पे नहीं सुना, देन द पर्पस ऑफ जस्टिस इज बीइंग डिफीटेड, करेक्ट?
Yes, sir.
जैसे प्लेंट फाइल हुई,
Yes, sir.
किसी लेस कॉम्पिटेंट लॉयर से ड्राफ्ट कराई, उसमें बहुत सारी कमियां रह गई,
Yes, sir.
उसके बाद ऑर्डर 6 टूल 17 में आदमी आता है, तो अगर उस एप्लीकेशन पे न सुना जाए
Yes, sir.
तो फिर तो जस्टिस इज नॉट बीइंग ड्यूली imparted टू दैट पर्सन।
Yes, sir. So this is where we have to draw the distinction that if it is necessary, then it should be heard. But if multiple adjournments are sought, multiple applications are filed, that should be avoided.
और ऑर्डर 2 रूल 2 का पर्पस क्या है सीपीसी?
Sir, it is to ensure that there is no multiplicity of proceedings and all the claim is decided in the one suit itself. So basically, it provides that the suit shall include whole of the claim and all of the reliefs that can be claimed from that suit.
और मान लीजिए प्लीडिंग्स कंफ्यूजिंग है, एज ए जज आप बैठी हैं, आपने पढ़ा, आपको लगा कि वो थोड़ी सी दे आर नॉट वेरी क्लियर, तो आपके पास क्या तरीका है उसको क्लियर करने का, प्लीडिंग्स क्लियर करने का?
So I can examine the parties, I can examine the documents, I can also refer to the interrogatories, and I can also ask from the pleader.
बिल्कुल ठीक बात है। ऑर्डर 10 रूल 2 का इस्तेमाल बहुत कम कोर्ट्स कर रहे हैं आजकल,
Yes.
है ना, ये नोटिस किया गया है बाय सुपीरियर कोर्ट्स।
Okay, sir.
इसकी वजह से प्लीडिंग्स में क्लैरिटी शुरू से नहीं आती है, तो अल्टीमेटली जो जजमेंट होता है दैट इज ऑल्सो कंफ्यूज।
Yes, sir.
अगर प्लीडिंग्स पहले से क्लियर कर लें और बहुत प्रॉपरली इश्यूज फ्रेम कर लें, तो एविडेंस भी कन्फाइंड हो सकती है, प्लीडिंग्स भी क्लियर हो सकती है, जजमेंट में भी क्लैरिटी आ सकती है।
Yes, sir.
अगर इस पे सुपीरियर कोर्ट्स बहुत इंसिस्ट करें
Yes, sir.
और इस स्टैंड पॉइंट से डिस्ट्रिक्ट कोर्ट के जजेस को जज करें, तो क्या आपको लगता है कि बहुत सारी अपील्स जो कंफ्यूज जजमेंट के खिलाफ फाइल होती हैं वो कम, उनमें कमी आ सकती है?
Yes, sir. Yes, sir. I feel that if the parties clearly explain what are their issue at, and it is clear, then lot of appeals can be avoided.
So this is one way of speeding trials and delivery of justice.
Yes, sir.
Is there any other way also, in your opinion?
So first is, as I said earlier, also reducing the adjournments because a lot of time they take adjournments. This leads to delay. Then second is streamline the process of serving summons because a lot of time goes in serving summons, and then parties take a lot of time in appearing in the court. So this also leads to a lot of delay. Third is the time that goes in execution, as the Supreme Court had also pointed out recently that a lot of execution applications are filed. So, in my opinion, when I talked to a judge, they told me that it is at the part of the executive magistrates that they are not executing the orders, so they should also be sensitized. These are some of the things that I feel could be improved.
करेक्ट, करेक्ट, करेक्ट। अब एक प्रॉब्लम ये आती है
Yes,
ऑन
sir.
द प्रैक्टिकल साइड, एक तरफ तो आप कहते हैं कि साहब अपनी चॉइस का लॉयर एंगेज करने का हर एक को राइट है,
Yes, sir.
और दूसरी तरफ उस लॉयर के पास काम इतना ज्यादा है कि वो भाई एक दिन में 5 केसेस में, 6 केसेस में, 10 केसेस में अपियर हो सकता है।
Yes, sir.
इसी ग्राउंड पर वो एडजर्नमेंट लाता है रिपीटेडली, ट्वाइस और थ्राइस, तो will it be wise to reject that amendment? Because in that case you will be defeating that purpose, कि भाई वो अपनी चॉइस के लॉयर से तो आर्ग्यू करना ही नहीं पाएगा अगर आपने रिजेक्ट किया, he has to bring forth another lawyer.
So I think one or two adjournments can be granted if sufficient cause is shown. But if multiple adjournments are granted, then I think I need to tell that lawyer that it is the duty to maintain the cases and to make the discipline accordingly in the cases.
Do you think
Also,
your oral saying will be of any worth to that lawyer?
sir,
He is
I feel as a judicial officer,
multiplying his cases.
sorry, sir.
The lawyer is concerned with multiplying his cases to make, obviously to get more money, to earn more money.
Yes, sir.
अब ये जो oral advice है, will it really matter to that lawyer?
So I feel
प्रैक्टिकली क्या तरीका हो सकता है उसको चेक करने का, बताइए।
So I feel that if it persists, then cost can be imposed because then it will deter the lawyer from taking multiple adjournments. Also, sir, I feel that law is a profession where we have to balance between justice and between our financial needs. So, saying that I have to take multiple cases will not do good. So that is why just lawyers have to understand the responsibility in that case also. One thing that I can feel is that engaging interns, like we can use these interns, they can learn at the same time and they can appear in the court, so teaching them properly can also help reduce the burden.
Hmm, good. सब्सटैंटिव लॉज में आपको कौन सी लॉ सबसे अच्छी लगी?
So I feel substantive laws में criminal laws as my favorite, otherwise all laws are equally good.
पार्टनरशिप
Yes, sir.
बिल है, ठीक है।
Yes, sir.
उसमें एक पार्टी दूसरे को नोटिस देती है टू बाय पोस्ट, रजिस्टर्ड पोस्ट,
Yes, sir.
कि इसको डिसॉल्व ट्रीट किया जाए इस पार्टनरशिप फर्म को,
Yes, sir.
तो ये नोटिस कब से इफेक्टिव होता है?
Sir, from the date which is mentioned in the notice or from the date when it comes to the notice of the other party.
Supposing the date mentioned in the notice is 1st of December 2025, और रजिस्टर्ड पोस्ट जो भेजती है वो दूसरी पार्टी को डिलीवर होता है 15 दिसंबर को,
Yes, sir.
रेजोल्यूशन की डेट क्या मानी जाएगी इसमें?
So 1st November, it will relate back.
यानी 1 दिसंबर
December.
और जो सर्विस की डेट है उसमें जो 15 दिन या 1 महीने का गैप है, उसमें अगर कोई चीज पार्टनरशिप फर्म करती है तो जिम्मेदारी दूसरे पार्टनर पर नहीं जाएगी कि पहले पार्टनर पर नहीं जाएगी जिसने नोटिस दिया है?
It will usually relate back according to the provisions of Partnership Act. But by the doctrine of holding out, if any third party has been prejudiced, then the party has to compensate for that. If due to the conduct of that party, any third parties has taken any action, then that party has to compensate for that.
The other partner who has not been served upon the notice within the span of 15 days or 1 month, उसके ऊपर लाइबिलिटी कैसे आप डाल देंगे? उसको तो पता ही नहीं था कि ये पहली वाली पार्टी डिसॉल्व कर रही है इस प्रीवियस प्रायर डेट से।
Uh,
ये
so
गलत
I
नहीं
think
होगा?
that the party that is sending that will be liable, and the party that comes to the knowledge that will be liable from the date when it comes to his knowledge.
देखिए, पार्टी की लाइबिलिटी तो तब होती है जब फर्म डिसॉल्व हो जाती है।
Okay,
उसके
sir.
पहले तो बराबर लाइबिलिटी होती है ऑफ ऑल दी पार्टनर्स।
Yes, sir.
तो मेरा यही क्वेश्चन है कि जिसने नोटिस दिया है
Yes, sir.
उसने अगर कोई पहले की डेट लिख रखी है और दूसरी पार्टी पे सर्विस ऑफ नोटिस दूसरे पार्टनर पे बाद में होती है, तो डिसोल्यूशन की इफेक्टिव डेट क्या ट्रीट करनी चाहिए और क्या की जाती है?
So I think then it will be from the date when it comes to his knowledge. So, sorry, sir. I will read more on this.
ठीक है मैम, एनीथिंग यू वुड लाइक टू आस्क?
Okay, so what do you understand by proper party and necessary party?
Sir, sorry, ma'am. Ma'am, necessary party is the one without which the suit can't proceed and no effective execution can be done. Proper party is which is required for comprehensive decision of the suit, but the suit can proceed and execution can be done. For example, necessary party can be all the co-partners in a partition suit, and a proper party can be a subtenant. For example, in the suit between landlord and tenant.
Okay. Difference between set off and counterclaim?
So, ma'am, sorry. Set off is basically the amount that is in an ascertained amount that the defendant is claiming. Counter claim can be based on other cause of actions also. It is not restricted to merely money suit. So it can be in a restitution of conjugal rights. They can ask for divorce or any other cause of, or based on any other cause of action.
Okay. Are you comfortable with Transfer Property Act?
Yes, ma'am.
Okay. Marshalling?
Marshalling means that when two or more properties are mortgaged and one of them is mortgaged to another person or sold to another person, that subsequent buyer or mortgagee can ask the other mortgagee or other mortgagee to satisfy his debt out of the first property. This is marshalling. So this is basically arrangement between the parties.
Okay. So, what do you think about part performance? The doctrine of performance क्या convey करता है?
Ma'am, doctrine of part performance is given in section 53A of TPA. It basically provides that if parties have entered into agreement in writing that a property will be transferred, immovable property is to be transferred, and the other party is ready and willing to perform his part, and they have taken possession, then his rights can't be defeated by the other party, but it is subject to the rights of the subsequent transfer.
Okay, perfect. Uh, Indigent person के बारे में बताएं.
Ma'am, it is given in Order 33. Indigent is a person who does not have sufficient means to file a suit. So that is why, in lieu of Article 39A of Constitution, which provides that free legal aid should be given, an indigent will be exempted from paying the court fees.
Okay. What do you understand by constitutionalism?
Ma'am,
Constitutionality, constitutionalism, constitution.
Constitution is a document which provides all the rights and how the structure of the country is to be governed. Constitutionalism is basically keeping a check on the powers of the government so that it does not misuse the powers and it remains in line with the constitutional principles. And constitutionality means whether the statute or the act of the government is in line with the constitution. So, a constitution is a document. Constitutionality is the principle to check the misuse, and constitutionalism is the method through which it is enforced, that it is in line with the constitution.
Well answered.
अगर
Puneet
किसी
sir.
लॉ को सुपीरियर कोर्ट्स ने अल्ट्रा वायर्स भी कॉन्स्टिट्यूशन डिक्लेयर नहीं किया है और ट्रायल कोर्ट को ये लगता है कि this law is violative of the Constitution of India, तो ट्रायल कोर्ट जज के पास क्या ऑप्शन है?
So trial court judge can frame its opinion and go for reference under section 436 of BNSS if it's a criminal case, and in civil case under section 113 of CPC. Then it can refer it to the High Court that I have this opinion regarding the validity of this act or ordinance, and it is necessary to decide this dispute.
Very good. You seem to be very well prepared with your answers.
Thank you, sir.
अच्छा, आप पंजाब से हैं और राजस्थान में अपेयर हो रहे हैं, कहीं पे आपसे पूछा गया कि अब राजस्थान में आप सेलेक्ट हो जाएंगी, वी आर
Yes.
होपिंग एंड वी कैन
Yes.
सी दैट आल्सो दैट यू आर वेल प्रिपेयर्ड, आंसरिंग
Thank
वेरी
you.
वेल। अब अगर पंजाब में वैकेंसी आ गई फिर छोड़ के वापस अपने?
No, ma'am. As of now, actually there is 3-year rule, so anyway I can't come to Punjab. And once I have been there, I have learned that I have been accustomed to that. I will continue in Rajasthan.
ओके, तो फिर आप आपका ये कहना है कि 3 साल की वजह से तो मैं वैसे भी पंजाब में एग्जाम दे नहीं पाऊंगी, तो
Yes, ma'am.
3
So
साल
I
के
will
बाद
be.
यू नॉट कंसिडर योर स्टेट?
Ma'am, as of now, I am considering Rajasthan only. I am considering present only, so I am focused on Rajasthan only.
ओके,
Hmm.
पुनीत सर प्लीज।
Hi, Muskan. Muskan, my question is, you are a civil judge, Jaipur, civil judge junior division. A suit for recovery has been filed in your court, and in the WS, the defendant admit his claim that I have to give this amount to the defendant.
Yes.
So, being a civil judge, what would be your call?
Sir, I would proceed under Order 15 that if the suit can be disposed at the first hearing because the parties are not at issue, so I will decide the suit accordingly.
Okay. And what about Order 12, Rule 6?
Yes, sir. I can use that also. Admissions. I can give judgment based on admissions also.
So, which one is the better one?
Sir, if it is at first hearing, then I feel Order 15 is better because at the first hearing it will be disposed. But if it is at subsequent stages that the party is admitting, then I can use Order 12, Rule 16, Rule 6.
What do you understand by the protest petition?
So protest petition is filed when a charge sheet is when a closure report is filed by police officer. So the complainant or the victim can file. So the victim can file a protest petition that the magistrate should take cognizance on this, and it can be treated as a complaint, or the magistrate may treat it as a ground to order investigation.
Perfect. One last question. What do you understand by doctrine of escheat?
The doctrine of escheat means if there is no legal heir of any person, then the property will vest with the government. It is provided in Article 296 of the Constitution and Section 29 of Hindu Succession Act.
Perfect. Over to you,
Highly
sir.
appreciated the way you are answering, the confidence, everything is highly appreciated, my dear.
Thank you,
True,
ma'am.
ma'am. True. Over to you, Sunena, ma'am. Perfect. Muskan, perfect.
Thank you, ma'am.
Thank you, sir. Hello, Muskan. Good afternoon.
Good afternoon, ma'am.
Muskan, I just heard you saying the term holding out, and there is one other term we use, holding over. तो आप दोनों में difference बता सकते हो?
Yes, ma'am. Holding out is in context of partnership, that one person is representing himself as the partner, and based on his assurance, some third party gave some credit to the partnership firm. Then that person will be liable. Holding over is in the context of tenancy, that a person who is whose tenancy agreement has ended, but still he is continuing in the possession with the permission of the landlord. Then it is tenant holding over under Section 116 of TPA.
Good, good. So now let's jump to static GK of Rajasthan.
Yes, ma'am.
तो राजस्थान की जो कल्चरल और हिस्टोरिकल हेरिटेज है वो बहुत रिच है, इस वजह से
Yes,
बहुत सारे फोर्ट्स हैं राजस्थान में।
Yes, ma'am.
तो कौन से फोर्ट को हम ग्रेट वॉल ऑफ इंडिया भी बोलते हैं?
Ma'am, चित्तौड़गढ़ फोर्ट?
नहीं।
Sorry, ma'am, I'm not able to remember that.
No.
I'll look into it.
No issues. लार्जेस्ट फोर्ट इन इंडिया कौन सा है?
Ma'am, is it चित्तौड़गढ़ फोर्ट?
Yes. Okay, good. So Rajasthan, with how many states in India does Rajasthan share its border?
Ma'am, Punjab, Haryana, Gujarat, and MP.
You're missing out on one state.
Delhi.
No. No issues. Longest river कौन सी है राजस्थान में?
Chambal River.
Great. Largest district कौन सा है with respect to area?
Jodhpur.
No.
Jaipur.
It's Jaisalmer.
Sorry, ma'am. Sorry. Yes, Jaisalmer. Yes.
No issues. Name 3 dynasties जिन्होंने राजस्थान पे रूल किया है in past.
Yes, ma'am. First is Raja Savai Maharaja Jai Singh.
I'm asking you dynasties. राजवंश कौन से रहे हैं?
Rajputs, then Pratihars, Gujars.
ओके. और अगर हम राजस्थान की बात करें तो एक कॉन्सेप्ट है बीमारू स्टेट्स का जो 1980s में डेवलप किया गया था. इसके बारे में कुछ आइडिया है आपको?
Sorry, ma'am. I will read about this.
No issues. So great attempt, Muskan. That's all from my side. थोड़ा सा factual data बस आप brush up कर लीजिए. You're already there. All the best.
मैम आप एक बार ना मुझे राजस्थान का बता दो क्या क्या करना है, क्योंकि ना मैंने डांस वगैरह तो पढ़ लिए थे, जैसे कलबीलिया डांस, क्योंकि मैंने हॉबी में यही मेंशन किया है कि मेरा डांसिंग और रीडिंग है.
अच्छा, ओके. तो देखिए डांस फॉर्म्स हो गए आपके, इंपॉर्टेंट मॉन्यूमेंट्स, डायनेस्टीज, रिवर्स, डिस्ट्रिक्ट्स. स्पेशली वो डिस्ट्रिक्ट्स देख लीजिएगा जो पाकिस्तान से बॉर्डर शेयर करते हैं. कुछ कुछ बॉर्डर्स जैसे लॉन्जे वाला बॉर्डर स्पेसिफिकली वो पूछ लेते हैं कि कौन से डिस्ट्रिक्ट में है. ठीक है. लार्जेस्ट, लॉन्गेस्ट, शॉर्टेस्ट ये सब तो आप देख लीजिएगा. उसके अलावा कुछ फेयर्स एंड फेस्टिवल्स होते हैं राजस्थान में, वो जरूर देख लीजिएगा. ठीक है. हाँ, तो ये कल्चरल हेरिटेज से रिलेटेड जो भी पैरामीटर्स है राजस्थान में, जैसे लोक देवताओं की बहुत मान्यता है राजस्थान में, ये इनके बारे में आप जरूर पढ़ लीजिएगा. ठीक है.
और ये बीमारू जो भी आपने बताया था वो क्या है?
बीमारू स्टेट्स का एक कॉन्सेप्ट डेवलप किया गया था 1980s में, ऑल्दो अभी आजकल हम उसको इतना रेलेवेंट नहीं मानते. ठीक है. तो इसके बारे में थोड़ा सा स्टडी कर लीजिएगा कि राजस्थान को क्यों इंक्लूड किया गया था इस कॉन्सेप्ट के अंडर और अभी क्या चेंजेस हुए हैं जिसमें बेटरमेंट हुआ है. ठीक है. और इसके अलावा जो भी हाई कोर्ट से रिलेटेड डेटा है ना, स्ट्रेंथ ऑफ द जजेस, ठीक है, प्रिंसिपल सीट कहाँ है, सर्किट बेंच कहाँ है, ये सब चीजें भी जरूर एक बार देख लीजिएगा. ठीक है. ऑल द बेस्ट.
जीके पे फोकस करना है आपको और वी आर होपिंग दैट यू विल बी सिलेक्टेड.
थैंक यू मैम.
Yes, Muskan, we are hoping we will soon meet you as a civil judge, Rajasthan.
Yes, sir. Thank you.
All the very best. Perfect.
Thank you.
Have a good day.
Thank you.